Exactly, because North Carolina General Statute 93B says that as board members of an occupational licensing board subject to that law, you have to be here. What are we covering today? Bobby, who's also from the Attorney General's office, and I are going to split this presentation up. I'm going to cover three things with you: the open meetings law, the public records law, and your favorite topic, rulemaking. So, open meetings law. North Carolina law generally favors meetings being open. There's some exceptions. What does it mean for it to be an open meeting? Well, first of all, who may attend an open meeting? Is there any limitation on who may attend? Generally, no. Anybody is entitled to be at a meeting that is an open meeting, no matter who they are. There are some conduct. They do have to comport themselves in a non-disruptive way to some degree, but you cannot stop anybody from coming to an open meeting. So what constitutes a meeting that is subject to the open meetings law? This law covers all official meetings of public bodies. An official meeting doesn't necessarily mean you all have to physically be there in the same room. An official meeting is defined as a meeting, assembly, or gathering together at any time or place, or the simultaneous communication by conference, telephone, or other electronic means of a majority of the members of a public body. And it also states the purposes, which would include basically anything that's within the jurisdiction of the public body: hearings, deliberations, voting, or otherwise transacting public business. So a majority of the members of a public body must be present in order for this to constitute an official meeting subject to the open meetings law. And the absence of a quorum means that the meeting is not official. It's come up before: is a committee considered to be a public body? And the answer would be yes. So if there's a committee with 4 members, 3 members have to be there to make a quorum, because that's the majority. If you don't have a quorum, then it's not an official meeting, but obviously you cannot transact certain business if it's not an official meeting. So the question, is this meeting covered by the open meetings law? Basically, if you're doing anything that is considered within the jurisdiction of the business of that public body, yes, you are covered, and you're required to meet the requirements of the open meetings law. Information gathering and fact-finding sessions are also covered by the open meetings law. Some of you might recognize this picture. I won't raise it again if you don't remember it. So the question might come up, depending on how volatile your meetings are: can you limit the media coverage of your meetings or keep people from recording them? And the answer is generally no. You may not stop reporters from coming in, and you may not stop people from recording your meetings if it's an open meeting. There are some exceptions if you're in closed session, but generally speaking, you have to let people record your meetings. Another question that might come up: do you have to let members of the public or media actively participate in your open meetings? And the answer to that, fortunately, most people would think, is no. You are not required to let them participate. You have to let them in, you have to let them record it, you don't have to let them actively participate. Now, there might be some exceptions, such as there might be a public comment period to rulemaking, or your board's bylaws may allow for a public comment period. But generally speaking, there is no statutory requirement that you let members of the public participate in your meetings. So what do you do if somebody becomes disruptive during a meeting? Well, the statute says that the presiding officer of the meeting should ask the person who's disruptive to leave. Hopefully this won't come up in your meetings. And willfully refusing to leave a meeting if you're disruptive is a Class 2 misdemeanor. I think realistically what would happen if the presiding officer asked the person to leave and they didn't, somebody would be calling the police, and it would be the police that would press charges. You know, the board members shouldn't go tackle them and drag them out of the building themselves. All right, so if you have a meeting subject to the open meetings law, what do you have to do? You have to keep minutes, a recording, some record of the meeting. This includes committee meetings. I don't know if this is always done, but technically you're supposed to keep minutes of those meetings. Every public body is required to keep full and accurate minutes of all official meetings, including closed sessions. Public bodies must make these minutes publicly available for inspection and copying, except for the minutes of the closed session. And a public body may satisfy this requirement through audio or video recordings. So if you have an audio or video recording, you don't necessarily need to make minutes. Now, I don't know if they keep minutes of committee meetings all the time, but technically that should be done. Additionally, with closed sessions, there should be minutes of the closed sessions, but those should be noted as such in case there's a public records request, so you can, because you have to describe why you're not turning those over for inspection and copying if that arises. So when can a public body go into closed session? This comes up frequently. Okay, so the reasons, you'll notice in your handout, if I've got something up there with a lot of small writing, generally these are 2 slides per page, but on the ones with small writing, I tried to print that out on a whole page so you can actually read it. Just real quickly, we don't have to read through all this, but some reasons to go into closed session: to prevent the disclosure of information that's privileged or confidential, to consult with your attorney on matters where the attorney-client privilege would apply. There's some specific things I don't think we generally need to get into, negotiating a building lease, those sorts of things. Some other reasons to go into closed session: to consider qualifications, competence, performance of a public officer or employee, to hear or investigate a complaint, charge, or grievance by a public officer or against a public officer or employee, or to plan, conduct, or hear reports concerning investigations of alleged criminal misconduct. I don't think the other things you'll probably have to deal with. So the question is, how do you go into closed session? You can't just say, okay, everybody get out, we're in closed session. To close a session, a public body must identify the exemption, justifying closure, and vote during an open meeting to hold a closed session. So when voting, the public body is supposed to refer to the specific statutory exemption relied on. So going back, you want to have a copy of 143.318.11 with you at your meetings if you anticipate going into a closed session, so you can cite the reason you're going into closed session. Okay, so if the public body indicates that it will discuss confidential information, it has to identify the law that makes the information in question confidential. Could be several reasons for that. We'll get into some of that later. If the board indicates that it's going to discuss pending litigations, it's supposed to identify the parties to the litigation. Some more exemptions to the open meetings law. Okay, and this is a big one for boards. Because obviously not everything you talk about with investigations is criminal. A lot of it's a licensure matter. So under 143.318.18, I hope that's correct. I can double check that. A public body authorized to investigate, examine, or determine the qualifications of applicants for occupational licenses or take disciplinary actions against such licenses. That is an exemption to the open meetings law. Those do not have to be, those discussions can take place in closed session. Additionally, preparing, approving, administering, or grading occupational license exams are exemptions to the open meetings law. This can also take place in closed session. Obviously, if you're going to be drafting an exam, it wouldn't make any sense to have that be an open session with somebody coming in and recording that. And if you're meeting with respect to an individual applicant for licensure or in respect to an individual holder of a license, that can be in closed session. So this 143.318.18 is something you may need to cite frequently if you want to go into closed session to have these sorts of discussions. Okay, this has come up, not necessarily with this board, but I've seen this on the news. Can I send text messages to other board members during a meeting? This has actually come up before. It's not an official position. There's a lot of law regarding text messages. They're really fuzzy areas to whether they constitute documents, et cetera. But generally speaking, the open government advocates have taken a strong position that sending text messages to other board members or anything to do with board business during a meeting is a violation of the open meetings law. that's not been litigated yet as far as I know. So practically, what's probably okay is if you send a text message saying, hey, do you want to go to, Larry's for lunch? That's probably not a problem because it doesn't relate to board business. You can't send a text message saying, how are you going to vote on this motion to another board member? Okay, so that was the open meetings law. Any questions? I may or may not be able to answer them. No? Okay. Moving on, more sunshine law, public records law. And this may be something that is going to be more of a concern to the staff members of a board who are doing most of the file retention. However, as board members serving on committees, you may be sent files. You might have the files for applicants or the files for licensees at home. You may be reviewing things regarding disciplinary matters at home. So you may become the custodian of public records. So this is important. Okay, here's the bottom line on public records. And you can zone out for the rest of my presentation if you want to. You need to know that everything you do in connection with your licensing board either is a public record now or eventually it will become a public record. There aren't exceptions to this. Even if it's confidential now, eventually it will not be anymore. A public record can be in any format, including electronic. Emails, documents, even if it never gets printed out, it's a public record. You need to be really careful about what you put in writing and assume that anything you put in writing in connection with business associated with your board will eventually end up being seen by everybody. It could be seen by people you work with, the media, your parents. So be really careful about what you put in writing, especially if you're critical of fellow board members, licensees, politicians, judges, that sort of thing. You should be on the lookout for whether or not an issue related to your board business might turn into the subject of litigation. If you're working on something that you think might become the subject of litigation at some later point in time, you might want to consult with your attorney early to make sure you're doing everything you can to protect what privilege or confidentiality there is with those documents. Be on the lookout for confidential information, which we'll get into in a little bit, before you transmit documents. And be aware that pretty much anybody can get a copy of a public record at no cost or very little cost. Okay, so getting into the specifics. What is a public record? Pretty much everything's a public record. All documents, papers, letters, maps, books, photographs, et cetera, regardless of the physical form or characteristics. So it does not need to be printed out. That's made or received pursuant to law or ordinance in connection with the transaction of public business by any agency of the North Carolina government or its subdivisions, and this would include your board. So here's some more information on what is an agency. You guys are considered an agency within the law. That's all you need to know. So who can get a public record and do they have to pay for it? Just like the open meetings law, the answer to the question of who can get a public record is pretty much anybody. Even if they're an out-of-state media organization, they can get it. They're entitled to get this under the Sunshine Laws. And also pursuant to 132(1)B of the North Carolina General Statutes, public records have to be provided at no cost or minimal cost to the person requesting it. Minimal cost means the actual cost of reproducing those documents. And in the days of email and electronic documents, that's usually going to be nothing. Okay, so some things that are not considered to be public records. Confidential communications are exempt from the requirement that they be turned over pursuant to a public records request. So what is confidential communication? It's a written communication to any board, and I'm just going to talk about boards here because that's who you are, made within the scope of the attorney-client relationship by an attorney at law. So one question that comes up is, if I'm an attorney and I send something to my board, that is most likely privileged. However, if you send something back to me this exemption does not cover you. There's another exemption that might cover you, but this is not it. So even though my communications as an attorney to you are clearly fall within this exemption, your communications back to me might not. We'll get into anticipation of litigation, and that's where you might get some protection in your communications to your attorney. So basically, one exemption is written communications by an attorney made within the scope of the attorney-client relationship to the board. Okay, some more things that are not considered to be public records. State and local tax information, public enterprise billing information, and this comes up. Address confidentiality program information. Sometimes you might get licensees that do not want their addresses listed. You know, obviously a lot of licensing boards may allow a licensee to opt to disclose information on the website or not, and that's fine. But if there's a public records request, if they're not in the address confidentiality program, which is defined by statute, their address is public record. It is not something that an individual has a right to keep out of the public record. And so this is just something to consider because I think there's some confusion. Licensees do not have the right to keep all of their address, email addresses, that sort of thing out of the public record. If they say they're part of the address confidentiality program, that's a really specific thing. My understanding is a lot of it is mostly to protect victims of domestic violence, that sort of thing. If they don't specifically cite that, they're probably not in that program. So what is confidential information? Okay. Confidential information can include trade secrets if they meet all these conditions. If you're negotiating with an individual who might be providing education or some sort, they might say that something they're providing is a trade secret. But in that case, in order for it to be confidential, it has to meet all of this criteria, including being designated as confidential or a trade secret at the time of the initial disclosure of that information. Another thing that's confidential is anything that reveals an account number for electronic payment. The other one you probably won't have to deal with. Okay, more things that are confidential information not subject to the public records law, or not subject to public records requests. Anything that reveals the electronically captured image of these things, signature, date of birth, but only if the agency has those items because they are on a voter registration document. I'm pointing that out because some people think these things are automatically confidential, and they're not. They're only if it's because they're on a voter registration document. There's some stuff about professional seals. You probably won't have to deal with that. Okay, another thing that comes up, settlement agreements entered into by the board. Can these ever be confidential? And the answer is no. Any settlement agreement entered into by a board as a state agency is public record. Furthermore, no agency of North Carolina government can approve, accept, or enter into a settlement if the settlement provides that its terms are confidential. And this also includes things that may be attached to the settlement agreement. You cannot necessarily get around this by just referring to some other document somewhere else that's not in the main body, because 132 1.3c states that this includes all documents which reflect, are made, or utilized in connection with the terms and conditions, blah, 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 including but not limited to correspondence, settlement agreements, consent orders, checks, and bank drafts. So basically this means that if you're going to enter into a settlement as a public body, that is subject to public record. That you cannot make that confidential. There are some very limited exceptions regarding medical malpractice suits and the like. You want to consult your attorney if there's any medically related information. Generally speaking, a board cannot enter into any sort of confidential settlement agreement. Other information that can be confidential, that can be kept out of the public record. Trial preparation materials. So anything that you write in connection with a potential legal proceeding. And what's important is it doesn't necessarily have to be a legal proceeding that's already filed. It could be something that you prepare in anticipation of a future legal proceeding. That's where your protection in your communications to your attorney comes in. If you're talking to an attorney, a lot of times it's going to be because there's a potential legal proceeding against the licensee. I mean, it could even be somebody who comes to your board meeting, a member of the public, and trips and falls in the parking lot. That's a potential legal proceeding. You want to pay attention to that because this only applies to your communications if they're made with a potential legal proceeding in mind. If you've got communications that were created in anticipation of a legal proceeding, and there is a public records request, and you want to keep those out of the public record, you're going to have to identify that it's being kept out because it's in anticipation of litigation. And it's possible if the person protests, you could end up in court litigating whether or not that's genuine. Another thing to note is even if you have that protection temporarily because you've written something to your attorney, you're anticipating a legal action, some crazy member of the public wants to sue you as a board member, eventually it's still going to become public record. So you want to think really carefully about what you put in writing. 3 years after the conclusion of a legal proceeding, it all becomes public. So there's no such thing as confidentiality that's going to last forever. So definitely keep in mind, if you put anything down in writing, eventually it's going to be a public record. Yes. Yes. For instance, as your attorney, I might ask you to prepare a document for me. I might say, can you write down what happened and send it to me in an email? Or you may on your own be keeping notes with it in the back of your mind. Ooh, this doesn't look good. I might get sued as a board member. Those are documents that you're creating in anticipation of litigation. Okay, so that's where you get your protection from. But it's a temporary protection, and it's certainly something that has been argued about in court. You could end up in court over the legitimacy of whether or not you really were anticipating litigation. So basically, if you've got it in your head, oh, we may be sued, or oh, we may have to sue somebody, or this may end up in an administrative action, that's anticipation of litigation. But as I said, anything you take, I mean, any notes, anything like that, any emails you send, 3 years after the matter's closed are going to be public record. Other things that are confidential, social security numbers and other personal identifying information. And this is where, as custodians of public records, you guys need to be really careful. Especially the social security numbers, it's a real hot spot. Agencies have a really hard time complying with this because social security numbers are all over the place. Technically, even within an agency, you really shouldn't be sending stuff that has social security numbers on it. It's best to just redact those or black them out prior to sending any records, even within your own agency. 132, 110. Governments need to minimize the instances in which the information is disseminated. I would advise board members, if you get anything with social security numbers on it, just take a black marker and black it out. I would advise staff to redact that information prior to sending it to you if it's at all possible. Leaving the last 4 might be okay, but generally you shouldn't be sending anything around that has a full social security number on it. Some stuff that you can't do with social security numbers. You're not allowed to collect social security numbers unless there's a specific reason and you're authorized by law to do so. Occupational licensing boards can get them as part of the application procedure for identification purposes, but you can't just ask for them without good reason. When you collect a social security number from an individual, an agency is required to segregate that number on a separate page or otherwise have it on there in a way where it can be easily redacted. An agency cannot fail when collecting it to provide, okay. if you're collecting a social security number from somebody and they ask you, why do I have to give you my social security number, the agency must provide an explanation. And the agency can't use the social security number for any reason other than the one that's specifically told to that person. More things. A government entity cannot intentionally communicate or make available to the general public a person's social security number or other identifying information. So what's other identifying information? Okay, so this is a little confusing because the statute says that identifying information for purposes of public records request and what's confidential has the same meaning as in GS 14-113-20B, which is a criminal statute, except that it doesn't include a bunch of things. So that's kind of confusing because you have to read both of those together. Basically it's the same thing as what's in this other statute, except it doesn't include a whole bunch of other things. So what does that mean? What actually is identifying information that's confidential? So reading those two things together, basically this is, and it's not showing up there, if you look in your handout, I took the list of things that's in that criminal statute, 14, 13, 20, and crossed out the ones that are exempted. So Social Security and EIN numbers are confidential, driver's license, state ID, passport numbers, and there's a whole bunch of things. And the list is provided to you in the handout. You may want to just look at it there. I'm not going to read through all of this. But some things that actually, yeah, do you have a question? Where I presume they mean passwords to get onto websites or access account information. Where are you on the list? I'm sorry. Can you? Okay. Yeah. So if you need a password to sign on to, if a licensee has a password to sign on to their information on the website, you can't. If there's a public records request for passwords, the public records request asks for all passwords for licensees. That's confidential. You don't have to give that out. However, you'll notice some things that are not confidential are email addresses. If you look at 8, those are things that are exempted. Email addresses, internet account numbers, internet identification names, those are public records, subject to public records request. So this comes up because I don't know about the Q board, but I know the Home Inspector Licensing Board sometimes gets some individuals who are very protective of their information. So this will give you some guideline as to whether or not that is something that you can give out pursuant to a public records request. The things on the list cannot be disclosed. Now, there's a couple things that are crossed out. Those can be disclosed because what's confusing is you have to read these two statutes together to figure out what's subject to public records, because they cite a criminal statute saying, well, everything in this other statute is confidential except for these things. So this is how to read it together. So if it's on this list and it's not crossed out, that is confidential information, not subject to public records request. Well, presumably that information belongs to the person holding the password, so that would not be subject to a public records request. Now, they could grant permission to give it out, but no, that would not normally be, a password would not normally be something subject to public records request. Because, I mean, obviously, if you think if anybody could get it, it would compromise the security of that person's account. Okay. Any other questions about this? Really quickly, driver's license numbers, if it's on a law enforcement record, that's not confidential. One other thing to point out, there's one ambiguous thing on here that's confidential. Any other numbers or information that can be used to access a person's financial resources. That's a little vague. It's just something to have in your head and to be on the lookout for. So some things that are not confidential information. These are subject to public records requests, and this comes up because we have secretive licensees out there. First and last names, email addresses, residential and business addresses, dates of licensure, disciplinary actions, dates of birth in the licensure file, those are all subject to public records requests. This does not mean that your board needs to post these things on their website. You don't have to do that. It just means that if there's a public records request, these are things you'd have to turn over. If they request a licensure file, you redact things like social security numbers first, obviously. But these are not items. An individual cannot say, you're not allowed to turn over my email address. Okay, so what happens if there's a public records request and there is confidential information on there, such as social security numbers, personal identifying information? If it's a disciplinary file, there might be correspondence to an attorney. So basically what you need to do at that point is forward it to legal, get everything that could be relevant to the public records request, get it to your attorney to be redacted. Because just because a record has confidential information in it doesn't change the record from being subject to a public records request. All it means is that that information is going to be redacted. Social security numbers will be redacted. Any correspondence to the attorney that's in anticipation of litigation will be pulled out, but you still have to respond to the public records request. And you can only take out the very limited information that is confidential. A few more things that you can't do with social security numbers. You can't put it on a card. You can't require somebody to transmit their social security number over the internet unless it's encrypted. So you can't just say in an email, send me your social security number. You can only ask for it if there's some way to protect that, if it's encrypted or there's a secure connection. You can't require somebody to use their social security number to access an internet website unless there's some additional requirements, password requirements on there. You're not allowed to print somebody's social security number on any materials that are mailed to that individual or presumably anybody else. Okay, some more stuff to watch out for in terms of public records. Be really careful about medical information. With occupational licensing boards, you're going to see this at least in a couple contexts. Sometimes with disciplinary actions, somebody may have a medical excuse. Why did they screw up on a particular day? They were sick. And you might be receiving medical records that way. Or it could be that somebody got hurt and they claim it's because of the negligence of a licensee and they're sending you medical records. You need to be really, really careful with medical records. If you can, I would avoid possessing them unless you absolutely have to. It'd be better to leave them in the possession of your attorney if you can do it. The confidentiality of medical records is covered by federal law HIPAA. You can't keep these records, if you have medical records, in with the rest of a file. You have to segregate it in some way that it's easy to keep those confidential. So, and you definitely want to talk to a lawyer before you transmit anything with medical information on it. Okay, so I think that was everything for public records law. Are there any questions about public records before we move on? Okay, so we're on to everybody's favorite topic, rulemaking. Rules basically are laws. So we've got statutes and then we've got rules. Rules have the force of law. And they're not pretty to make. Okay, so in North Carolina, as an occupational licensing board, when you make a rule, the authority on that is going to be the Rules Division of the North Carolina Office of Administrative Hearings. And the contact information for them is in there. They're a great resource. Contact them. There's a lot of confusing stuff. Their website is a great resource. A lot of the forms you need are on there, summaries of the procedures. Okay, so why does it matter? Rules are laws, and everything else that the board does is not a law and doesn't have the force of law behind it. And I stole some of these slides. I got permission first, but some of this stuff comes straight from the Rules Review Division, their own PowerPoint presentation. So this is one of their slides. Okay, so do you need to have it in a rule, or can it be something else? A rule means any agency, regulation, standard, or statement of general applicability that implements or interprets an act of General Assembly or Congress, or a regulation adopted by a federal agency, or that describes the procedure or practice requirements of an agency. So that we talk about two general categories of rules. Legislative rules, that's legislative rules arise as a result of the delegation of power from the legislature to the agencies. They go beyond just interpretation, and they set down additional substantive requirements. The other kind of rule that we talk about are procedural rules, and these are the how rules. They describe how an agency will carry out its assigned tasks and the requirements for how non-agency persons must deal with the agency. So, or is it something else? Well, a rule does not include some things, and I think this causes some confusion, and it causes much angst, apparently, at the Rules Review Division. A rule does not include interpretive statements. It does not, if the board wants to put out something that's just interpreting a statute or rule, this shouldn't be in a rule. I'm not entirely clear how you're supposed to do that, but it's not supposed to be in a rule. It doesn't include forms. A board may use forms that its licensees need to fill out. That's fine, but that's not, the form should not be included in a rule. And statements of agency policy made in the context of other proceedings are not rules. Okay, so apparently, according to the Rules Review Division, this is another one of their slides, there's a big question as to whether there's a such thing as an interpretive rule. And this is the quote that they put in there. Generally speaking, interpretive rules carry no sanction. Interpretive rules and policy statements of agencies are excluded from the rulemaking provisions. So according to the Rules Review Division, you cannot make an interpretive rule. It has to be one of the, either a legislative rule or a procedural rule. And I'm sure you guys know they'll kick a lot of stuff back to you. What does all that mean? If you have to do something now you didn't do before, if you can't do something you previously could do, if you can be penalized for not doing it or for doing something you previously were allowed to do before, then it's a rule. If it's a rule, then you have to adopt it according to the rulemaking process as a rule. You can't hide behind an interpretive statement or some other device to avoid it. Okay, so why does it matter? Well, a rule is not valid unless it's adopted in substantial compliance with this article. And here's the kicker. An agency cannot seek to implement or enforce against any person a policy, guideline, or non-binding interpretive statement that meets the definition of a rule and has not been adopted as a rule. It can be a real pain in the butt to pass a rule, but if it's something that should be in a rule, you cannot get around it by doing an interpretation. Okay, so what are some reasons an agency might want to adopt a rule? You need it to accomplish the agency's purpose. The General Assembly may enact something that requires you to pass a rule. I think there's something recent with military spouses where this applies. There might be a federal mandate, a court order, or there could be a petition for rulemaking. Okay, here's some new things. I mean, I know there was, you guys probably remember the Executive Order 70, and there was, what was it, Senate Bill, was it 781? Previously, that made it, added additional requirements for certain agencies to passing rules. Well, some of that's been codified now, and it does apply to your boards in General Statute 150B 19.1. One thing is agencies must adhere to developing and drafting principles, and we're going to talk about that more. You must conduct an annual review of your rules. You must post proposed rules on your website. The agencies must determine if policy and program overlap. I don't know exactly what that means. We'd have to call OAH. You must quantify costs and benefits, and this is important. Agencies must consider two alternatives if there's a substantial economic impact. The agency must prepare certification if the rule is purported to implement certain federal law. And agencies within the government, cabinet, or council of state must obtain certification that the agency adhered to drafting principles. That also applies to you. That makes sense. Okay, so what are the developing and drafting principles that were talked about? These are the principles. An agency may adopt only rules that are expressly authorized under state or federal law and that are necessary to serve the public interest. It can't just be a good idea, it has to be necessary. An agency shall seek to reduce the burden upon those persons or entities who must comply with the rule. The rules must be written in a clear and unambiguous manner and must be reasonably necessary to implement or interpret federal or state law. In terms of what is clear and unambiguous, it's a bit of a mystery to me. A lot of communication with the Rules Review Division is often necessary to determine that. And I think the staff generally knows who to contact over there. An agency shall consider the cumulative effect of all rules adopted by the agency related to the purpose for which the rule is proposed. You cannot adopt a rule that's unnecessary or redundant. One thing that comes up a lot is if there's something that's written in a statute, you do not need to repeat it in a rule. They won't let you repeat it in a rule. If it's already someplace else, they're not going to let you say it again. So it has to be something new. And something else I think that's new is when appropriate, rules shall be based on sound, reasonably available scientific, technical, economic, and other relevant information. Agencies must include a reference to this information in the notice of text required under that statute. And rules shall be designed to achieve the regulatory objective in a cost-efficient and timely manner. So those are the principles that you must adhere to in drafting rules. This is new, and the Rules Review Commission specifically asked me to point this out to you. Before an agency that is within the governor's cabinet submits the proposed text of a permanent rule change, the agency must submit the text of the rule to the Office of State Budget and Management and obtain certification from that office that the agency adhered to the principles we just talked about. So that's new. You want a rule change, you need to send it to the Office of State Budget and Management first for certification. Does that not apply to you guys? Are you not in governor's cabinet? Okay, so that's not you. So you don't have to worry about this then. I think you still have to, if there's a substantial economic impact, I think you have to still do the fiscal note. Okay. Right. And we'll get to that, to the fiscal note in a minute. Okay, so 3 kinds of rules you'll be dealing with as a board: permanent rules, temporary rules, and emergency rules. This nice handy-dandy flow chart in there, we'd be here all day. Some things to note: you not only have to submit the rule, you have to have an explanation of the reason for the rule, a citation of the law that gives you the authority to make the rule, effective date, and these other requirements. So you can read that. Okay, so do you need a fiscal note for the rule change? Before an agency publishes in the register the proposed text of a permanent rule that would require the expenditure or distribution of funds subject to the State Budget Act, it must submit the text of the proposed rule to the Office of State Budget and Management and obtain certification that the funds that would be required are available. So if it has a monetary impact and it's going to cost any money, you need to go through the Office of State Budget and Management. And there's these additional, so they'll give you a certification. Is that the holdup that you're talking about? In terms of the substantial economic impact, this is also a change. I think previously it was a substantial economic impact was defined as $3 million, and now it's $500,000. So there's more analysis that needs to be done if it's anticipated that there's going to be a substantial economic impact. I'm not going to go through all of this. How am I doing on timing? Okay, fiscal note requirement. At least $500,000 of an effect in a 12-month period. So that's the time restriction. So in analyzing whether or not there's a substantial economic impact, the agency must do these things. Determine and identify the appropriate time frame for the analysis. Assess the baseline conditions against which the proposed rule is to be measured. So if you're saying there's going to be a $750,000 impact compared to what? If the rule is not implemented, so that's what they mean by that. You have to talk about who's going to be affected by the rule. Estimate any additional costs that would be created by implementation of the rule. And then there's even a discount factor in here. For costs that occur in the future, the agency shall determine the net present value of the cost by using a discount factor of 7%. I have no idea where that came from. It's not arbitrary, I'm sure. So what needs to be in the fiscal note? You have to have a description of who's going to be affected, a description of the type of expenditures that the affected persons would have to make to comply with the rule, description of the purpose and benefits of the proposed rule change, an explanation of how you estimated the expenditures, and a description, this is important, of at least 2 alternatives to the proposed rule that were considered by the agency and the reason that those alternatives were rejected. The alternatives may have been identified by the agency or members of the public. So I guess you're always going to have to come up with something to fulfill that. Okay, timing and permanent rules. There's lots of stuff on timing. I don't know if it's worth going through it all. It's in your notes, and the website really does contain pretty good information on the timing. One question that comes up is sometimes you have a proposed rule, and in the course of things, there'll be a change made to the rule. There'll be a public comment, et cetera, or somebody will just catch a typo and the rule change. So the question is, do you have to go through that whole process again? Well, you have to look at whether or not it differs substantially from the proposed form. There's a grammar correction, or there's something that's just done to make it a little bit more clear, make it flow better. You don't have to go through all of this again. If you're changing something substantive about that would affect whoever's affected, something that actually changes the way the rule works, then you're probably going to have to go through reposting, et cetera. This is just talking about one way a rule might not go into effect is if you get 10 or more written objections to a rule. If there's 10 or more written objections to a rule, then it gets sent to the General Assembly. And the General Assembly may introduce a legislative bill to disapprove that rule. Okay, so this is what happens if there's a legislative bill to disapprove a specific rule. If the bill is ratified by the General Assembly before the rule becomes effective, the rule will not become effective and isn't entered into the administrative code. One thing to be clear on is that proposed actions on rules may be withdrawn by the agency at any time. So if you submit a rule and there's a big public outcry, you get 10 or more written objections and it gets sent to the legislature, the agency can just say, hey, wait a second, we're just going to pull that back. Never mind, and start over again. So it doesn't necessarily have to go all the way through the process. The agency has the right to pull the rule back, and then it doesn't go into effect, obviously. Okay, temporary rulemaking procedure. You'll see this is a smaller flow chart than the last one, so I'm not going to go through. One thing to emphasize with temporary rules, you need to fill out a findings of need form. So what are the reasons you might need a temporary rule? Well, one that I think most people think of is a serious and unforeseen threat to public health, safety, or welfare. And this has got to be something pretty serious, thinking like bodies in the street and death and mayhem. Some other reasons, recent act of General Assembly or U.S. Congress, change in federal or state budgetary policy, recent court order. There's a couple other reasons. And you also have to answer the question, why is adherence to notice and hearing requirements contrary to the public interest and the immediate adoption of the rule is required? So on that form, you're going to have to answer that question. So if it's possible to go through the permanent rulemaking process, if that's not going to be harmful to the public, they're going to make you go through permanent rulemaking. Okay, the other kind of rulemaking, emergency rulemaking. This is an even simpler flowchart than temporary rulemaking. Okay, some things that you're going to have to tell the Rules Review Commission in order to have an emergency rule. What is the need for the emergency rule? Has the agency provided the public with abbreviated notice, and then you have to describe it. If it's possible to do it, you need to do it. And then there's this question, which I don't think is proper English, at least that I can see, but this is right off the form. Why is adherence to notice and hearing requirements contrary to the public interest and that the immediate adoption of the rule required by a serious and unforeseen threat to the public health or safety? I did not write that. That's off the form. You have to answer that somehow. And then you also have to answer whether or not the agency has specific statutory authority for the adoption of the emergency rule. And if so, have you met the statutory criteria for adoption? And then you have to attach a copy of the statutory authority. I think the emergency rule, right, and I think there may be reasons to go either way. The emergency rulemaking process is even more abbreviated than the temporary. I mean, you can do the emergency rulemaking even faster than temporary rulemaking. So I think that's the difference. And maybe I'm not sure, but you might have. The Rules Review Commission asked me specifically to point these things out to you. That the government agency has to go through the Rules Review Commission and fill out the certification form that can be found on the website before you can submit the rule. Basically, they want you to go to their website and make sure you've read it before you put a rule into them. The agency must approve the fiscal note before the rule is published. So if there's a requirement for the fiscal note, the agency has got to actually approve that fiscal note. What does that mean? That means you have to come together as a public entity and vote on it by the majority of the people there. The rulemaking agency is the board. Therefore, that means that you actually have to, if you want to adopt a rule after the comment period, it doesn't automatically come into effect. You actually have to get together in a meeting, and this could be by phone, and vote on it to have that rule become effective. Last but not least, how long does the rulemaking process take? According to the Rules Review Division, this is what they say. They say to expect it to take about a year if there's no legislative review, and about 2 years if there is. That's what they said. So how they calculated that, I don't know, but that's straight from the horse's